The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of the Center for Judicial Engagement, as well as special guest Robert Everett Johnson. This week on the show, net neutrality, probable cause for a search warrant, and a challenge to a pair of SEC enforcement actions. Rob, let's start things off in the Sixth Circuit.
All right, so this case out of the Sixth Circuit is a really neat little Fourth Amendment case. The basic facts here, you have a guy who the police have probable cause to suspect that he is some kind of a drug dealer. He's been driving around with somebody who is a known drug dealer. He's pulled over. They find a large amount of cash on him. They find 2 cell phones, one of which has this known drug dealer's number on it. But what they don't have, it turns out, is probable cause to search his home. But they nonetheless obtain a warrant to search his home, and they find there a large amount of marijuana that they then use to convict him of being a drug dealer. Now, he moves to exclude that evidence at trial, and the Sixth Circuit on appeal actually says that that evidence should have been excluded, and they overturn his conviction of being a drug dealer.
I think what's really important about this decision is that it focuses on the fact that the Fourth Amendment does not just protect physical people. It protects their property. It protects their places. It protects their homes. The second component of the Fourth Amendment, which focuses on the probable cause requirement before a warrant may issue, focuses on the particularity with which an officer must detail his reasons to believe that he'll find a particular thing in a particular place. And the court makes the point throughout this opinion that even if this guy is a drug dealer, it does not follow that we have probable cause sufficient for a search warrant to believe that his particular house contains evidence of his drug dealing. And in point of fact, they did not find evidence of the drug dealing with which he was thought to be associated with another drug dealer. That drug dealer was involved in heroin. They found only marijuana in his house, and ultimately the jury did not convict him on the basis of finding any heroin.
Yeah, the key thing here to understand this opinion is that all of the evidence that the police had that made them think that he was a drug dealer involved things that he was doing outside his house. And so what the Sixth Circuit is saying is just because you're doing things that are illegal, or you might be doing things that are illegal outside your house, doesn't mean that the police have probable cause to search your home.
What do the police need to do to get probable cause to search the home in this case?
Well, they need to have evidence that there is a nexus between this guy's drug dealing activity, alleged drug dealing activity, and the home itself. In this case, they didn't really have any. They had his association with another drug dealer. They had a previous drug conviction. They had a dog that alerted on his car when it was parked in front of this heroin dealer's house, but they had nothing specific to his home. And in fact, they waited until a few weeks after arresting him on the basis of his alleged heroin-related activity before they even searched his home in the first place. So ultimately what the court concluded is you can't just rely on the fact that the guy is a known drug dealer. What you need to do is establish a nexus, and the warrants, by simply reciting vague things about drug crimes, specific facts concerning his involvement with another drug dealer, and the fact that he had been previously convicted of an unrelated offense, is not enough to search somebody's house.
And a neat little footnote on this case, the court finds that this lack of particularity, this lack of connection to the house, is so glaring that the officer who executed the warrant wasn't acting in good faith, and actually names that officer by name in the opinion. It's a little bit of what you might call a bench slap.
Yeah, and this is really an important point, because the exclusionary rule, which the court applied in this case, that provides that when the Fourth Amendment is violated, ordinarily the evidence that is secured through violating the Fourth Amendment gets excluded from a subsequent criminal trial, has been riddled with exceptions over the years. And the good faith exception is, first of all, a very permissive exception that all too often swallows the rule. And second, has metastasized over the course of the last few years. And this court actually looks carefully at the officer's conduct leading up to securing the warrants, finds an insufficient connection between the information that was available to him and his decision to search this particular house, and says, no, we're not going to give you a good faith exception.
Yeah, I mean, really, honestly, while this case is probably rightly decided, you might question whether it's really a faithful execution of recent Supreme Court precedents on the good faith issue. I mean, if this case had been decided by the Supreme Court prior to Justice Scalia's death, I imagine it would have come out completely differently.
My personal opinion on that is the good faith exception is a bad faith interpretation of the Fourth Amendment, so I'm totally okay with that.
Okay, well, let's move on to the next case, which comes out of the 11th Circuit. Evan?
Yeah, this case takes us into the wacky world of administrative law where an individual can be subject to a civil enforcement action that subjects him potentially to heavy fines and even perhaps jail time, and not have access to a federal court to challenge the constitutionality of the procedure by which he is going to be deprived of his property. He's an individual who is subjected to his SEC enforcement action. Congress has provided that the SEC can choose to, in effect, prosecute an individual either through an administrative tribunal or through a federal court. In this case, the SEC chose to go through an administrative court, and the individual challenged this, saying that, look, insofar as an administrative courts, there aren't any juries, the rules of evidence are different, and, oh, by the way, the administrative law judge is not in fact a judge. He is an individual who is a member of the executive branch and has been actually appointed through means that are constitutionally questionable. I have an issue with that. I want to go to a federal court and I want to vindicate my constitutional rights.
And it's worth noting, just by way of background, that the SEC has vastly stepped up its use of these non-judicial proceedings in recent years as part of its attempts to go after supposed financial criminals. And that, I mean, the deck is really stacked against you in every respect in these administrative proceedings. You get no discovery. Hearsay is admissible against you. You have no opportunity to depose the government's witnesses before trial. I mean, it's really not what we think of as a judicial proceeding in any realistic sense.
I mean, it's fundamentally not a judicial proceeding. I mean, all of the guarantees that we associate with fundamentally judicial proceedings, a jury that finds the facts, a judge who is presumptively independent, who is appointed for good behavior, you don't find that. And this is what this guy is challenging, and the 11th Circuit's response to this is, well, you'll still get meaningful judicial review after the fact, so this is not really a problem, and you can't seek relief in the federal district court.
What's he alleged to have done?
So the defendant here has been accused of insider trading. He purchased some stock, and then some news came out that was good for the stock. The price went up, and then he sold it. But there's no, we don't know the facts. We don't know whether he's guilty or not, and really that's something that a jury should be finding.
Right, and that's his fundamental complaint, is that even if you characterize this as a civil action, and I think that that's permissive. I mean, he's being penalized for wrongdoing. That's fundamentally a criminal proceeding, and you should be indicted by a grand jury for stuff like that. But even setting that aside, Seventh Amendment provides that if it's a civil suit and the amount in controversy is over $20, you get a jury. He doesn't have a jury. That's a problem.
So the district court agreed with you, Evan, and issued an injunction. What happened in the 11th Circuit?
So the 11th Circuit basically says you have to exhaust your administrative remedies. What that basically means in plain English is you've got to go through this entire administrative show trial and then appeal it within the agency. And then at the very end of the day, after you spent a ton of money on all of this, then finally you can go to court and you can actually raise these constitutional issues.
Right, and he can't even bring a civil action against the SEC after the fact as a consequence of this unconstitutional treatment because sovereign immunity. So he has no civil recourse after the fact. And the other point that's worth making here is that the idea that judicial review is meaningful after this, you need to keep in mind that the record that's developed by this administrative law judge, his findings of fact and his conclusions of law are presumptively correct and will be deferred to pursuant to federal statute by a reviewing judge after the fact. So you have systematic bias that's built into this whole process, and he is unable to challenge it until it's too late.
Okay, well, let's keep things in the administrative law sphere and move on to the net neutrality case out of the D.C. Circuit. Evan?
Yeah, this is an 180-page opinion that we could probably spend all day discussing, but we'll try to keep it to just 10 minutes or so. It's the culmination of the FCC's multi-year effort to enact binding net neutrality rules. Net neutrality is the idea that broadband providers should treat all internet traffic the same, regardless of source or content. And in order to pursue this policy, the FCC had to reclassify broadband providers for the purposes of federal law. into entities that it has more authority to regulate. Specifically, it had to classify them as telecommunications providers rather than information providers.
Yeah, and maybe it's a little arcane, but it might be worth going into just a little bit of detail on what that distinction means, right? So a telecommunications provider is basically like a pipeline, whereas an information services provider is providing you some sort of service that you're using beyond the pipeline. So the question basically is, when you are purchasing broadband internet from Comcast, is Comcast selling you a pipeline that allows you to access other things, or is it selling you an entire package that includes the pipeline but also includes things like an email address or access
are they
to
like
the
a
Comcast
railroad
home?
or a telephone service company, or are they like a cable company that exercises a good deal of editorial control over its content and providing it to listeners? That's the fundamental question. And beyond that, the other fundamental question, and this is why it's of particular interest to administrative law geeks, is the process by which this policy was enacted. It went through what is called notice and comment procedure, but the question is whether sufficient deliberation, sufficient consideration was given to all of the relevant factors before enacting a rule that's going to have wide-ranging economic and political consequences. Put succinctly, does arbitrary and capricious review, which is kind of the baseline standard for evaluating policies that come through notice and comments, really have teeth, or is it essentially a rubber stamp to which judges should effectively defer to agencies?
Well, and there's also a very important administrative law question here about what is the standard that applies when an agency changes its position. So here the agency had previously classified broadband as an information service, and it was reclassifying it as a telecommunications service. And so, the question is, when the agency changes its point of view, what does it have to do to justify that change? Does it have to do more than it would have to do to take that position in the first place?
And the basic fight between the majority and the dissent in this question is just how much deference agencies should give when they make wide-ranging policy judgments that affect millions of people in a very short span of time. What kind of evidence do they have to rely upon? Do they need to have empirical studies? Do they need to have an army of economists behind them? Do they need to do meticulous cost-benefit analysis? Or do they just basically need to say, we want to do this, we are equipped to do this, and it would be a valuable policy? And the fight between the majority and the dissent is which approach is appropriate. The majority broadly defers to the agency, says that we're not going to get into the economic nitty-gritty, let economists fight about that, we're reviewing courts, agency is expert, we'll defer to them. The dissent is like, no. Arbitrary and capricious needs to mean something. We have an army of economists on our side that say this is a terrible idea, and the few economists that the FCC did cite in developing this rule actually made arguments that undermine the FCC's policies. So this is a big fight over the role of a reviewing court in evaluating administrative law agency decisions.
Although, interestingly, the dissent doesn't say that it would have been unreasonable for the agency to classify broadband services as telecommunications in the first instance.
That's true.
Actually, what the dissent says is that it was unreasonable, having classified them one way, to then change its mind without providing any explanation for why it was making that change.
Right. So it's not so much an interpretive disagreement as a substantive disagreement with respect to the amounts of deliberation that went into the decision itself. And there's also a lurking First Amendment issue, which the majority, I think, uncharitably dismisses very quickly by essentially saying that, look, these broadband service providers are essentially a pipeline. That's all they are. They don't exert a lot of editorial control over the content. Therefore, we don't treat them like we would cable companies that exert a lot of editorial control. The problem with this, particularly in the way in framing this in terms of what the FCC is doing, is that it actually gives these broadband service providers a great deal of incentive to block more content and exert more control, which is allegedly what the FCC is trying to avoid in order to allow it to in order to carve out a space for the First Amendment. So the more content they block, the more robust the First Amendment protections that they are afforded actually become.
I mean, at the end of the day, I guess I'm less worried about the First Amendment implications of this than you are, Evan. I mean, it seems to me that Comcast really is realistically just a tube that is sending information. And just to take a step back here in terms of the history of this, you don't have to defer to administrative agencies to think that Comcast really is just a pipeline and not an information service. A bit of history: in 2005, this issue came up before the Supreme Court the first time when the FCC classified broadband as an information service, and there was a challenge saying that was unreasonable. And the Supreme Court split 6-3, and Justice Scalia actually dissented and said that under the statute, it was unreasonable to classify Comcast and other broadband providers as anything other than a pipeline, a telecommunications service, because that really is what they do. When you purchase internet service, what you are purchasing is nothing more than a pipeline to get you from your house out to the internet. Honestly, I really think that, at least from my perspective, when I'm purchasing broadband, that's what it is to me. I think Justice Scalia was right when he said that. I think that the agency was wrong the first time around when it classified broadband as anything other than simply a pipeline, a telecommunications service.
Mm-hmm. So I look at this through the lens of what is the freedom of the press. Freedom of the press, I think Eugene Volokh has persuasively argued, is ultimately the freedom to use mass communication technologies. The press was the mass communication technology available at the time of the framing. The modern analog to the printing press is there is no single analog. There are a lot of things that can now do what the press does. You can look at cable companies that provide good deal of content that serve as a conduit for content. You can look to, besides newspapers, Facebook and Twitter serve as conduits for speech. There is a great deal of control that is exerted by the providers or the facilitators of this content, but all of them are ultimately relying upon an analog to what the press was back at the time that the Constitution was framed. And I think that the proper lens through which to look at this in the context of the broadband service providers is precisely that. They are serving as a conduit, yes. Nonetheless, they are facilitating speech activities, and to the extent that they facilitate speech activities and exert any control over what they deem fit to serve as a conduit for, they fall into the same category. I think that the proper analog here is to cable companies, which the Supreme Court has properly recognized as entitled to First Amendment protections. And just speaking more about the perverse incentive problem, if the problem that the FCC is trying to address right now is the broadband service providers blocking content and charging differential rates for preferred content, the last thing that you want to do in order to facilitate that, if you're the FCC, or the last position you want to be in, is dealing with a court ruling that basically says, look, the more you block content, the more control you exert, the more First Amendment protection you get. So just to take a step back, I guess what I would say is, to me, a broadband internet provider is much more analogous to a phone company than it is to a cable company. The phone company also is facilitating communication. People talk over the phone. But phone companies for years have been regulated as common carriers and they can't privilege certain phone communications over other phone communications. I don't think there's anything crazy about saying that a broadband internet provider has to fall into that same regulatory category as the phone company. And I certainly don't think that the internet providers of Comcast is exercising editorial discretion when it's passing on essentially a pipeline of information from point A to point B. Are you comfortable that the analysis that the court provides in the First Amendment context would allow it to regard something like Facebook or Twitter as more than a conduit for information?
I think the court's analysis may be somewhat lacking, but I think that there is a meaningful distinction between a Facebook or a Twitter, which moderates the information and that provides a platform that is more than just a pipeline. Facebook is with its information stream that you can, what do you call it, the feed? All of that is,
and we know that there's a lot of editorial
moderated
control.
In a way that Comcast simply does not moderate your use of the internet.
Would you like it to moderate it more?
No, and I think that's the reason that people support net neutrality.
Gentlemen, I think we're running out of time. Final thoughts? A deferential decision?
Deferential decision, yes.
Yeah, absolutely a deferential decision, and the case comes out the right way, but not for the right reasons.
Okay, that concludes the show. Thanks for listening. We appreciate you. For more judicial engagement, be sure to follow Rob and Evan on Twitter. Their handles are @FreeRangeLawyer and @EvanBurnick. And so until next time, this is John Ross from the Institute for Justice, clamoring for you to get engaged.